In January 2021, the UK government introduced new rules into the UK asylum system. These new rules were called the Inadmissibility Rules. That meant that they could decide that an asylum claim made in the UK was inadmissible, meaning that the UK Home Office wouldn't consider that asylum claim. They wouldn't even look at it substantively. There were rules called inadmissibility rules in the UK immigration rules before, but they were very, very limited as to when they would be used. And these much more extensive rules were brought in January 2021 to replace the Dublin Regulations, which were part of EU law, which the UK was signed up for. And the Dublin Regulations and the inadmissibility rules brought in January 2021 had the same main purpose, and that was that EU governments, the UK government, thinks that asylum claims should be considered in the first safe country that someone has travelled through in their journey to safety. So the Dublin Regulations meant that if someone had travelled through another EU country on the way to the UK Home Office could say that they weren't going to consider the asylum claim in the UK and that the other country, maybe Germany, France, Italy, should consider the asylum claim. The Dublin Regulations stopped being effective in the UK as soon as the UK left the EU because of Brexit, so the UK government had to come up with new rules to replace them. You may also have heard about the Asylum Inadmissibility Rules because they are part of the Nationality and Borders Bill, which at the time of recording is going through Parliament. But these rules are already in place in the UK, and the Borders Bill would just put them on a statutory footing. They're already in place, they're already being used by the UK Home Office and have been since January 2021. When these rules were introduced, it was clear what the intention was from the UK government, but what wasn't very clear is how they were going to work in practice. Well, in fact, a lot of people didn't think they were workable, so they weren't going to work in practice. The intention of the inadmissibility rules were to replace the Dublin Regulations, to stop there being that kind of gap for the UK government to be able to remove people if they thought that other countries should be responsible for someone's asylum claim. The new inadmissibility rules had got some more worrying aspects to them as well. The clearest explanation of what the Home Office want the rules to be about is in the Home Office's own guidance, and they say that the inadmissibility rules allow an inadmissibility decision to be taken on the basis of a person's earlier presence in or connection to a safe third country. And that connection to is important. So you don't actually have to have been to a country, a safe third country that they want to remove you to. You need to have just a connection to that country, and what that means isn't yet clear. And it doesn't seem like that connection side of the rules has actually been used very much. It seems like so far it's people's presence in other countries that is being used, because that's probably a lot easier for the Home Office to establish. Having a connection to a safe third country is going to be very challengeable. So I think they're sticking with what's easier for them to prove, and that's someone being in another country. So the Home Office rules allow an inadmissibility decision to be made on the basis of a person's earlier presence in or connection to a safe third country, even if that particular country will not immediately agree to the person's return. More significantly, if someone is inadmissible, the new permissions permit their removal to any safe third country that will take them, not just a specific country or countries through which they have travelled or have a connection. So the Home Office are basically trying to say that by travelling through a safe third country, you've basically voided your right to have your asylum claim heard in the UK, and they will either try and remove you to the country you travelled through, or actually to any country that's considered safe, because it just needs to not be the UK as far as the Home Office are concerned. And the part about even if that particular country will not immediately agree to the person's return is important, because the Dublin Regulations have with them lots of return arrangements, EU return arrangements. But when the UK left the EU, there's no agreements for sending people back to other countries. And there's no new agreements that have been signed. And so far, returns have only happened on a case-by-case basis. There's been no general agreement about returns of people who've claimed asylum under these rules. So the basic part of this is if the Home Office think you travelled through a safe country on your way to the UK, they can use these rules to investigate whether your claim should be treated as inadmissible. And while your claim is being considered under these rules, your claim doesn't move forward in the UK at all. People are just stuck. If the Home Office say that your claim is inadmissible, they can try and remove you to a safe third country, and they won't look at your asylum claim at all. They won't look at whether you're in danger in your country. As far as they're concerned, it doesn't matter. They're not looking into your claim. It's not admissible. If the Home Office decide that these rules don't apply to you, or look at your claim under these rules and say your claim is not inadmissible, then your claim will be considered in the UK. The Home Office will decide whether or not your claim should be treated as inadmissible, and while they're deciding that, they will issue you with a document called a Notice of Intent. If they're not intending to think about these rules in connection to your claim at all, you won't get any document about the inadmissibility rules. But if they're considering whether these rules apply to you, they will issue this Notice of Intent. And there's pretty standard wording for these notices of intent. Most people are getting so far these notices after they've claimed asylum, usually after the asylum screening interview, but before the asylum substantive interview, although the Home Office guidance makes it very clear that they could do it after the substantive interview, and in fact they can use information you give in your substantive interview as evidence on which to make a decision about whether your claim is inadmissible. Of course, people are waiting so long for both the screening interview and the substantive interview at the time of recording that the Home Office might be issuing these notices before either of these interviews have taken place. The Home Office will collect evidence about your journey to the UK, any documents you've been issued in any other countries. They can use things like receipts. And the Home Office guidance, which we link to in our blog post on this topic, sets out the different kinds of evidence that they can use. The Home Office are able to basically just look and see if you arrived by a boat, because that indicates that you've travelled through another safe country, because they're able to use observations by a Home Office officer or another person in an official capacity relating to the person's method and place of entry to the UK. So if you arrive by boat in the UK, the Home Office is in a position where they can say, well, you almost certainly came from a safe third country, probably came from France, therefore we might consider you under these rules. They can use any evidence of anything you've said to any encounters with Home Office staff at this point, anything in your screening interview, anything in your substantive interview. Take a look at our blog post for more details about the kind of evidence that they can use. The important thing is that the Home Office need to make a decision about whether the rules apply to your case within about 6 months of you claiming asylum. They are able to extend that timescale if removal still seems a reasonable prospect and there's clear mitigating factors to justify the extension. Anecdotal evidence so far suggests they're not using that loophole very much, and that people generally are having to wait those 6 months and then they come out the other side and their claims are admitted to the UK asylum process. It was very hard to tell how in practice these rules would be used, especially when there were no return agreements in place. But towards the end of 2021, we got the first kind of evidence about the use of the inadmissibility rules that covered the first 9 months that they were in place, so the period of January to September 2021. And during that period, 6,598 people were issued with those documents called notices of intent, meaning that the Home Office was considering whether the inadmissibility rules applied to those people's claims. Of those 6,598 people, 2,126 people had their asylum claims admitted into the UK asylum process. So basically the Home Office had looked at their claims, had considered whether the inadmissibility rules applied to their cases, and had decided they didn't apply, therefore the people could progress into the UK asylum system. Of those 6,598 people who got notices of intent, 48 people had a decision of inadmissibility. So the Home Office had looked at their claims, looked at the inadmissibility rules, and has said, your claim is inadmissible to the UK. We're not going to process your asylum claim here because we have evidence that you travelled through another country on the way here. And of those people, actually 10 of them have been removed from the UK. An important factor in those decisions of the 48 people who the Home Office could say their claims are inadmissible is that 38 of them had actually been granted refugee status or similar status in another country. But it's really important to say that those people might not have known they had refugee status in another country. In some countries, people are granted asylum and are given no notice of it, or they have a very brief encounter with the authorities, are subsequently given protection, but it doesn't come with much practical substance in those countries, and they don't know or benefit from that status. The countries that people have been accepted to return to, even if they haven't actually been removed, are Switzerland, Germany, Denmark, Spain, Ireland, Italy, Slovenia and Sweden. So quite a range of countries, all European countries, but it's important to note that the guidance allows a safe country to be determined as basically any country in which someone's refugee convention rights wouldn't be breached. But so far, people have only been accepted to countries that are in Europe. It's good to know that some of the early concerns about these rules, such as whether people would be held in detention if they were having their cases considered under these rules, haven't come true. People have been detained, but only those that the Home Office are actually trying to remove. They've decided their claims are inadmissible and they want to remove them. It also wasn't particularly clear early on whether people would be entitled to asylum support, so housing and financial assistance. And it seems that people are able to access asylum support whilst their claims are being considered. There have been some legal challenges to the decisions that people's asylum claims are inadmissible. There's certainly been legal challenges when the Home Office has been attempting to remove people from the UK, but we haven't yet got a huge amount of information about these challenges because the vast majority of people are either still waiting for a decision if they've been issued with a notice of intent, and if they have been given a decision, most of those have been that they can carry on within the UK asylum process. So we will wait and see, and hopefully we will get some good information about successful challenges to these rules that can be shared. The big problem is that people's claims are being held up even further. There's massive delays in the asylum process at the moment. At the time of recording, 16 weeks wait to even register your asylum claim, weeks and weeks and weeks waiting for screening interviews, months, maybe years waiting for an asylum substantive interview, months, maybe over a year for an asylum decision. These rules factor in perhaps another 6-month delay whilst inadmissibility is being considered in your claim. So it really is a damaging aspect of the asylum system, even if most people are able to come out the other end and have their claims considered.